Mr. Crane, in July of 2020, in a July 2020 letter to the Department of Labor, the National Association of Manufacturers wrote that many ESG-focused funds have a stated goal of subordinating investor return or increasing investor risk for the purpose of achieving political and social objectives. Why is the only appropriate objective for an ERISA retirement plan ensuring that the participants have a sound and secure retirement?
For manufacturing workers who are depending on an ERISA plan, whether it's a defined benefit or defined contribution plan, they need that plan and their families need that plan to be there for them when they retire. So if you're an ERISA fiduciary and you're making decisions on behalf of that plan, whether it's what investments to choose, how to vote the proxies, or whether to rely on a proxy firm, you need to be making those decisions in the best interest of those plan participants so that the plan's savings, the plan's assets are there for them when they retire. And that's absolutely the bedrock of ERISA.
You mentioned my bill, the Protecting Prudent Investment of Retirement Savings Act. What protections does that bill provide?
So your bill would require that ERISA plan managers make decisions based in plan participants' best interests, both by investing based only on pecuniary factors, which are those that are relevant to the long-term performance of those assets, and ensuring that those fiduciaries are undertaking appropriate due diligence when it comes to both proxy voting and potential use of service providers like proxy firms. Both of those steps would be critically important to protecting ERISA beneficiaries' retirement security.
Professor Schossenbach, the term pecuniary comes from a unanimous Supreme Court decision that outlines the duty of loyalty. That decision states that ERISA's requirement to act for the exclusive purpose of providing benefits means financial benefits, such as retirement income. Can you explain why pecuniary is the right term to govern a fiduciary's investment decision?
Yeah, so I think an important part of the statute, of the proposed bill, is provides a definition of what a pecuniary factor is, and it ties it back to risk and return, right? So it focuses the fiduciary's attention, which should be laser focused on risk and return, and it cabins off these anything that isn't affecting risk and return. So it's hard enough to make investment decisions and build a plan menu and monitor the plan menu, and pushing the fiduciary to say, we're only going to focus on financial factors is, I think, sound policy. It is also most consistent with prevailing understandings of ERISA in the law right now.
Yeah, and it's common sense as well.
I don't disagree.
Professor, some ERISA-defined contribution plans allow participants to direct their investments from a menu of investment options. This menu constructed and maintained by ERISA plan fiduciaries, and if so, how is it constructed and maintained?
I don't think ERISA specifies an exact process, but I can probably give you an answer from sort of what best practices are at the moment. So when you're creating a defined contribution plan, typically the employer appoints an investment committee who are ERISA fiduciaries. They may be employees of the firm, and then they often retain an investment advisor to advise them on the construction of the plan. But it's not just constructing the plan that's important, it's the ongoing monitoring too. So if you're offering a mutual fund that has been offering subpar returns, you have a fiduciary obligation to remove it. If you find a product that is similar or equal but has a lower fee structure, you may have an obligation to put that into the plan. And so creating a structure where there's typically quarterly meetings and a professional investment advisor is how that's executed.
So if a participant instead chooses to make his investment selections through a brokerage window, why should that participant be informed that the plan's investment experts have not selected the investments in the brokerage window as being appropriate for a retirement savings portfolio?
Right, so I think that's an important part of this legislation that I don't think has been spoken to yet. So there's something called a brokerage window, which allows plan participants to and it depends on the scope of the window. You can broaden it to individual stocks, or you can keep it limited to a class of mutual funds. But it allows a participant to go outside the plan menu that's been constructed by this investment committee with the advice of the investment advisor. And then they're sort of on their own. It's no longer a curated plan. And so the bill, as I understand it, continues to allow people to do that, but it puts what I would call like a consumer warning label on their decision to do so. And I think one important part of that label is that it warns them that they may pay higher fees. I mean, one advantage of these plans is that you may have a lot of money in an individual mutual fund because of all the participants choosing it, and you get a lower fee as a result. You get a volume discount, essentially. When you go outside, you're probably paying essentially a retail fee. And one of the, and I can say this anecdotally, there's evidence that people sometimes use this window, and they kind of pick something very similar or maybe even identical to what's in the plan. They just pay a higher fee. So at least giving them that warning that they're leaving something that's been curated under fiduciary obligations and that has probably a lower fee structure is I think, helpful.
Okay, great.